All right, everyone. I'm going to call the proceedings to what passes for order here. I'm Gary Lawson, the Associate Dean for Intellectual Life. And about a decade ago, the first time he held this job, Jim Fleming started the wonderful tradition of recognizing and honoring the publication by the faculty of university press books. And this time around, by happy coincidence, Jim's book, Constructing Basic Liberties, A Defense of Substantive Due Process, happens to come at a time when we can double dip it with our Constitution Day programming, because it happens to be about constitutional law. I think it's fair to describe Jim's book as, shall we say, timely. So during our proceedings today, you're going to hear from Jim Fleming, the Paul J. Liakos Professor at Boston University School of Law. He's been with us for 15 years now, after a very distinguished career at Fordham. He will give some opening remarks. We will then have brief comments by myself and by Aziza Ahmed, who's joined our faculty this year as the R. Gordon Butler Scholar in International Law, after doing some pre-game warm-ups at Northwestern and UC Irvine. We are delighted to have her here with us. And we're going to try to keep our comments relatively brief to make sure that we have time to hear questions from you. So without further waste of time.
Gary?
Yeah, absolutely.
And if you don't have time to ask your questions,
tomorrow.
We scheduled a discussion group tomorrow, 12 to 1, in room 410.
Thank you, Jim. Yes, absolutely, absolutely. Without further use of our precious time, please join me in welcoming and honoring Jim Fleming.
Thank you, Gary. Is this working all right? Okay. I heard the roar of a wave that could drown the whole world. These lines from Bob Dylan's prophetic "A Hard Rain's Gonna Fall" express what I heard in Justice Alito's majority opinion in Dobbs. I heard the roar of a wave that could drown the whole world of personal autonomy and bodily integrity. Put another way, Dobbs may represent the second death of substantive due process, or at least the beginning of it. Now, what was the first death? Well, those of you who've had constitutional law know it was West Coast Hotel versus Parrish in 1937, decided during the New Deal, which repudiated the Lochner era's protection of economic liberties under the Due Process Clause. Now, our discussion of Dobbs will center on my new book, as Gary mentioned. Now, the book went to press just before Dobbs was released. Authors dream of writing a timely book. Well, frankly, I wish my book weren't timely at all. I wish our basic liberties were secure and ready for expansion through the ordinary struggles of social movement and constitutional change. Now, I want to give a shout out to several terrific research assistants who helped me with the book: Jeremy Perlman, Esther Miller, and Kyle Angelotti. And I greatly appreciate all the work of our communications and marketing folks, especially the incomparable Elizabeth Clancy. It's gratifying to have such a substantial audience. And so thanks also to the American Constitution Society and the Federal Society for publicizing it. Now, turning now to Gary and Aziza, few authors are as fortunate as I in having such thoughtful commentators. And finally, I could not have completed the book without the love and support of my sometime co-author and full-time spouse, Professor Linda McLean, here in the front. and our incredible daughters, Sarah and Catherine. Okay, so what is substantive due process? Because there are many 1Ls in the audience, I should briefly introduce it. The Due Process Clause provides, nor shall any state deprive any person of life, liberty, or property without due process of law. One reading emphasizes process, and the other reading emphasizes liberty as well as process. Now, substantive due process it involves interpreting the commitment to liberty in the Due Process Clause to protect basic liberties or fundamental rights, those essential to the scheme of ordered liberty in our constitutional democracy. Now, what basic liberties has our practice of substantive due process over the last century protected? Well, imagine that you are a constitutional archaeologist who digs up the bones and shards of a constitutional culture that I've listed on my slide. And I'll zero in on the right to marry and the right to decide whether to bear or beget children, since they're at the core of the debates right now. So the challenge you face is to decide whether these bones and shards fit together into and are justifiable within a coherent structure. That is the challenge I set for the book. Now, there are two radically different views concerning this list. The first was Justice Scalia's view, and it's reflected in the Dobbs majority opinion, that the list is a subjective, boundless product of rogue judges reading their own, quote, philosophical predilections or, quote, moral intuitions into the Constitution under the guise of interpreting it. But according to the competing view, this list represents what Casey called a rational continuum of ordered liberty stemming from reasoned judgment concerning individual rights to make certain unusually important decisions fundamentally affecting their destiny, identity, or way of life without compulsion by the state. And so on this view, this line of cases has been built out over time through ordinary common law constitutional interpretation, reasoning by analogy from one case to the next on the basis of experience, new insights, and moral learning, and making normative judgments about whether to extend rights previously recognized based on the basic reasons we protected those rights in the first place. Now, I defend the latter view, and in fact, I argue the list is pretty conservative when you look at it, since all of them, and it's no wonder, since all of the major decisions protecting rights from Roe through Obergefell were written by Republican justices. And those are the kinds of decisions that hardly anyone, conservative or liberal, wants the government to make for them. And so substantive due process has not protected any rights that anyone could fairly call frivolous or rogue, despite all the overwrought wailing by critics over the years. Now, in substantive due process cases, the conflict between these two views is encapsulated in the battle between the Glucksberg and the Casey frameworks for the due process inquiry. Now, in Dobbs, the new conservative majority held that the right to abortion is not deeply rooted in this nation's history and tradition or essential to ordered liberty. And those are two formulations of the test in substantive due process. Now, what is tradition? Let's distinguish two competing conceptions of tradition in the due process inquiry. One, I'll call tradition as concrete historical practices, versus two, tradition as abstract aspirational principles. And I've detailed them here on these slides. Now, Dobbs conceives our nation's history and tradition as historical practices. But I show in my book that the substantive due process line of cases protecting basic liberties from Meyer in 1923 to Roe, Casey, and Obergefell instead conceives tradition as abstract aspirational principles. Now, the court in Dobbs ruled that Washington v. Glucksberg provides the proper test And so due process protects only those specific liberties protected in the concrete historical practices as of 1868 when the 14th Amendment was ratified. And Glucksberg rejected the competing approach of Casey, which had interpreted our commitment to liberty and our traditions instead as abstract aspirational principles whose meaning is built out over time. And I give an example here on the board. All persons are created equal is part of our tradition in this sense, despite concrete historical practices of inequality, including slavery, Jim Crow, and gender discrimination. Therefore, on this view, being faithful to the 14th Amendment requires criticizing our historical practices of 1868, criticizing our historical practices because of commitments to aspirational principles of liberty and equality, as many scholars of race and gender, including Michelle Goodwin and Peggy Cooper Davis, have argued. Now, I have two slides here fleshing out the Casey and Glucksberg frameworks. Now, in dissent in Obergefell, which had adopted the Casey framework in extending the right to marry to same-sex couples, Chief Justice Roberts protested that the case, quote, effectively overrules Glucksberg, which he called the, quote, leading modern case interpreting the Due Process Clause. But as I demonstrate in my book, Glucksberg is the leading modern case only for justices who oppose and wish to shut down the practice of substantive due process. Indeed, he's right, Obergefell is inconsistent with Glucksberg. So are Lawrence v. Texas, which extended the right to sexual intimacy to same-sex persons, and Griswold versus Connecticut, which recognized the right to use contraceptives. In fact, I show every decision in the past century that has protected a basic personal liberty under the Due Process Clause is inconsistent with Glucksberg. Every single one. Not one of them would have come out as it did had the court been applying the Glucksberg framework. None protected rights as a matter of vindicating longstanding concrete historical practices as the Glucksberg framework conceives them. Instead, all of the decisions protecting basic liberties stem from judgments that our commitment to liberty as an abstract principle requires protecting rights to make certain decisions fundamentally affecting one's destiny, identity, or way of life. In short, the Casey framework. Now, before Dobbs, Glucksberg in 1997 provided a method of damage control for conservatives who opposed these cases, but did not have the votes to overrule them. So they had to settle for this far and no further. Today, conservative justices have the votes to overrule these cases, even though Alito's majority opinion in Dobbs denies that it casts doubt on any of them besides Roe and Casey. Now, Senator Lindsey Graham praised Alito's opinion in Dobbs for, quote, setting the right tone by assuring that it would not endanger other rights. But Justice Thomas's concurring opinion said the quiet part out loud. He said, if the court applies Justice Alito's approach, it will conclude that all of the due process decisions protecting personal liberty, personal autonomy and bodily integrity, including Griswold, Lawrence, and Obergefell, were, quote, demonstrably erroneous and must be overruled. In truth, the Glucksberg test would find that contraception, same-sex intimacy, and same-sex marriage, not to mention interracial marriage, which Thomas rather conveniently overlooked, are not protected liberties for the same reason that abortion is not. None of those rights, any more than abortion, was protected specifically in the concrete historical practices as of 1868. And more recently, and even as recently as 2020, Alito joined Thomas's statement in Kentucky clerk Kim Davis's case calling for overruling Obergefell. So if this court does not overrule precedents like Obergefell, Lawrence, and Griswold, it will be because of political judgments like Senator Graham's about Republican Party politics, not because of any legal framework. Now, the Dobbs dissenters rightly called out this hypocrisy and warned that Roe and Casey were, quote, part of the same constitutional fabric as those other precedents. They argued for the Casey view, not the Glucksberg view, as the best account of what our practice of substantive due process has been. Okay. And again, they argued that all of these prior cases protecting personal autonomy and bodily integrity have rejected the hidebound historical practices approach, Alito, Dobbs, and Dobbs, in favor of the abstract aspirational principles framework in Casey and Obergefell. Now, let's think back to my opening image of hearing the roar of a wave that could drown the whole world. I want to consider whether Dobbs represents a second death of substantive due process, or at least the beginning of the end. Now, before Dobbs, reports of the second death of substantive due process had been greatly exaggerated. Bowers, in 1986, tried to be the second death by narrowing the due process inquiry after Roe, but Casey, in 1992, revived it by broadening the due process inquiry. Glucksberg, in 1997, attempted to be the second death of substantive due process by narrowing due process after Casey, but Lawrence and Obergefell thwarted Glucksberg by applying the Casey framework. Now, Dobbs narrowed the due process inquiry back to the Glucksberg framework, and folks, I fear they now have the votes to make it stick. I don't think we're going to see any more Casey's or Lawrence's or Obergefell's reviving any kind of generative substantive due process in our lifetimes. So only time will tell whether Dobbs is more like Glucksberg, this far and no further, or West Coast Hotel, and thus the second death of substantive due process, repudiating a whole line of cases protecting personal liberties. Now, I just want to close, or let me just very quickly mention a couple of the other issues I deal with in the book, because some of you may have questions about some. I address a number of common objections to substantive due process. For example, that it, as Justice Scalia put it in his dissent in Lawrence, that it effectively decrees the end of all marriage legislation. Now, does Lawrence really put it on such a slippery, treacherous slope? Well, like Taylor, I say to Justice Scalia, you need to calm down, okay? And I devote 2 chapters to showing the types of arguments we make in constitutional law to get traction on slippery slopes, and the kinds of arguments beyond mere moral disapproval that we make to justify prohibiting traditional offenses like all of the horribles on his list. Now, finally, I also mentioned I deal with the arguments that this repeats the grave errors of Lochner versus New York. And what is the ghost of Lochner? Well, when I teach Lochner, I ask my students, why is Lochner infamous? What does it mean to summon the ghost of Lochner? And my response is that it means to charge someone with doing whatever it was that was so horrible in Lochner versus New York. Now, that response may sound vacuous, but it's not. The point is that people use Lochner to beat up their opponents. They use it as a rhetorical club. And although critics of Roe talk like there's one agreed upon understanding of what was wrong in Lochner, I demonstrate that every theory of constitutional interpretation and judicial review has a different conception of what was wrong with Lochner versus New York, and I detail all of them in a chapter. And I argued on the best understanding of Lochner, it's got nothing to do with it's got nothing to do with Roe and Obergefell. And then finally, some progressive and liberal critics want to rewrite Roe and Obergefell from the Due Process Clause to the Equal Protection Clause. This is the whole genre of rewriting Roe and Obergefell. And I argue that Casey and Obergefell give us all the arguments we need to justify them both as a matter of due process and equal protection. Applying interpretive charity to those opinions, you can piece together the starting points for making all the progressive and liberal arguments we need. And then finally, I won't go through this, but I sketched 4 criteria for deciding whether due process or equal protection is better. I've probably spoken too long already. But I just want to close with a few remarks on the future of substantive due process. Now, I want to offer a pep talk for dismayed liberals and progressives and words of caution for conservatives. Okay, first, the pep talk for the liberals and progressives. So, things look really bleak, don't they? Well, instead of quoting Dante's Inferno, abandon all hope, ye who enter here, I just say, abandon your hollow hopes, to use a famous formulation from Jerry Rosenberg. Abandon all hollow hopes that courts are going to protect your rights or save a people hell-bent on ruin from ruin, okay? Instead, I urge liberals and progressives to turn more to legislatures and executives than to courts. And here I include not only the national legislature and executive, but also state governments. Second, I encourage liberals and progressives to learn from and emulate what the conservatives did over the past 2 generations in resisting the Supreme Court decisions with which they vigorously disagreed. Pass laws that challenge or undermine objectionable Supreme Court decisions and provide occasions to narrow those rulings. Third, as the conservatives did, liberals and progressives should learn to appreciate the virtues of federalism as a structure for accommodating diversity and disagreement, especially when you don't hold national power and you need to resist. That shades over into my 4th point. Liberals and progressives should learn that federalism is a mechanism for resistance to the national government by states that disagree with the party in control of the presidency, Congress, and or the Supreme Court. Use state government when you lack power to resist the national government. Now, many liberals and progressives finally started to learn this during the Trump administration. I'm thinking of things like sanctuary cities, but climate policy and things like that as well. And 5th, to continue with federalism, I encourage liberals and progressives to turn to state courts as well as state legislatures to pursue constitutional justice. And here, the LGBTQ rights movement from Bowers in 1986 to Obergefell in 2015 is instructive. Only after a mostly successful run in state courts and state legislatures for a long time did LGBTQ rights litigators and advocates take the issue, for example, of marriage equality to the US Supreme Court in Obergefell. Finally, pursue minimalist strategies seeking narrow rulings when litigation in federal courts is unavoidable, and develop social movements that are committed to playing the long game and promoting the gradual transformation of the constitutional culture in your direction. In other words, do for reproductive freedom and LGBTQ rights what the conservatives did for the individual right to bear arms in the last 50 years. And finally, the words of caution for the jubilant conservatives. I caution jubilant conservatives who hope the long-awaited conservative counter-revolution is nigh. Be careful what you wish for. For years, what I mean by that is that these wishes for a Supreme Court restoration of the conservative Constitution that folks have said has been in exile since the New Deal liberal revolution, these wishes may be about to come true to some degree. But beware that such a court that carries out these wishes is likely to come to live in infamy, an infamy that may surpass even that of its prior incarnation, the Lochner Court. And I say that in fulfilling such conservative wishes, rather than protecting basic liberties, personal liberties, in substantive due process cases culminating in Obergefell, the court would truly repeat the grave errors of Lochner. Thank you. Thank you.
Professor Aziza Ahmed.
Thank you so much. Thank you so much, Professor Fleming, for inviting me to be a part of this event. It's really an honor and privilege to be here and to have the opportunity to comment on a book that, as Professor Fleming said, could unfortunately have not been written at a better time, but also to comment on a book written by someone whose work and scholarship has been so important and influential in this field. I also wanted to say before diving into the substance that, especially because there are so many students here, that I really recommend the book to people who are thinking about the Constitution in this current moment. It is a true immersion in the debates on substantive due process, and it's written with the clarity I think so many of us aspire to in our own writing. So thank you, Professor Fleming, for that as well. So for my comments today, I wanted to use the book, use Professor Fleming's writing about substantive due process and the rights associated with substantive due process as a way to really dig into the recent Dobbs decision. As many of us know, and as of course we've just heard, this past summer, the Supreme Court overruled Roe versus Wade, the decision that made abortion a fundamental right and decriminalized access to the procedure. One of the primary reasons, as Professor Fleming just noted, that the court overturned Roe, according to the majority opinion written by Alito, was that the correct analysis to understand whether or not there was a right to abortion was rooted in Washington v. Glucksberg, a case which requires asking whether the right to abortion was rooted in the nation's history and tradition. The court, and I quote, said that the right to abortion does not fall within this category, essentially of laws that are deeply rooted in history, in the nation's traditions, and in our idea of an ordered liberty. This decision was long, but for people who can get pregnant, women and others with the capacity to be pregnant, no amount of legal analysis or harmonization of constitutional theory would have justified writing their existence out of both history and the contemporary moment. Sure, it might be true that there wasn't always a right to abortion in the way that we might think of it today, or that the framers of the Constitution didn't have abortion on their minds. But the history of women's health in the United States is a tumultuous one, filled with death and illness during pregnancy, the taking of Black children from their mothers during slavery to support the slave economy, a rising male medical establishment in the 19th century that wiped out home-based midwifery, the activism of organizations like the Black Panthers and the feminist women's health movement, who opened their own clinics to get access to health care and reproductive health services. Today, these long histories of subordinations result in the marginalization and culminate in the marginalization of a continued marginalization of communities, in Black women dying in childbirth in multiples compared to white women and other women, the Trump administration tracking the menstrual cycles of girls in immigration detention, the sterilization of women in prisons in California in the early 2000s, and now the denial of abortion and miscarriage services even when a woman is near death. While there might not always have been a right to abortion, if there is another true story to tell about the history and tradition of this country, it is that people, women, especially Indigenous, Black, Latina, immigrants, women of color, and poor people of all races have had to fight for recognition at every turn to simply survive the existence of living in their own body. In their powerful dissent, Justices Breyer, Sotomayor, and Kagan note the problem of the historical analysis offered by the majority, which went all the way back to the 13th century to understand how to regulate abortion, a medical procedure, today. Those responsible for the Constitution, I'm quoting here the dissent, including the 14th Amendment, did not perceive women as equals and did not recognize women's rights. When the majority says that we must read our foundational charter as viewed at the time of ratification, except that we may also check it against the Dark Ages, they say, it consigns women to second-class citizenship, end quote. Though Professor Fleming stopped short of saying that this is what Kavanaugh and Barrett would do when they were appointed, his book, which was written before Dobbs, predicts the decision. In lamenting the loss of what Professor Fleming calls a moral reading of constitutional law, he shows that the court may instead turn to Glucksberg v. Washington as it did, the framework that was long advocated for in the dissents of Lawrence and Obergefell. In foreshadowing the dissent in Dobbs, Professor Fleming notes that it is a dangerous move for liberty and equality. And of course, Professor Fleming was right. Was another path possible? One obvious way forward available to the court to uphold at a minimum was the undue burden standard put forward in Casey. For many in the reproductive rights movement, it was a difficult thing to hope for, even as we did. The standard put into place by Casey v. Planned Parenthood said that if a legal regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking a pre-viable abortion, it is unconstitutional. The undue burden standard, as argued by Professor Fleming, the product in some ways sort of rose to prominence in a joint opinion, which spoke of reasoned judgment as the tradition that the court has always exercised. As the book notes, the tradition celebrated in Casey was not the history and tradition of Glucksberg, but rather an assertion of the due process inquiry, based in a dissent by Justice Harlan, in which due process is not a formula, but rather represents the balance which our nation, upon which the postulates of respect for the liberty of the individual is struck between that liberty and the demands of an organized society. From a reproductive rights standpoint, for decades, the undue burden standard proved to be a barrier to increase access to abortion. Judges repeatedly found that no legal regulation placed a substantial enough obstacle in the path of a woman seeking an abortion. Or they found that the purpose of a potential regulation, waiting periods, for example, informed consent laws, regulations that doors had to be a certain width, were not designed with the purpose of undermining access to abortion, but instead were health regulations designed to protect women. In the latter case, they happily deferred to the pretextual claims by conservative state legislatures who claimed that they were acting on women's health outcomes in the context of abortion, which was, of course, as many constitutional scholars have pointed out, a winning argument for conservatives when they realized that the fetus wasn't gaining traction as a sympathetic figure. In the mid-2010s, undue burden was reworked again in two cases, Whole Woman's Health and June Medical, which paid attention finally not only to the purpose, but the effect of the laws that were being passed to undermine abortion access. Understanding the effects of the law meant that the court revisited the actual impact the laws were having. In these two cases, they looked at the regulations designed to undermine abortion access, in these cases an admitting privileges rule saying that doctors had to have privileges at a hospital within 30 miles, and in Whole Women's Health, that plus another rule that said that clinics needed to have ambulatory surgical centers essentially to perform abortions. In these cases, the Supreme Court finally acknowledged that we had to look at the burdens of a law, not only its purported benefits. They finally looked beyond pretext, the pretext of supposedly helping women, which had now become a talking point, and instead carved a new path forward that would allow for the undue burden standard to strike down regulations. In June Medical, they even acknowledged that expert and lay witnesses said that there would be a disproportionate impact on the poor. This acknowledgement of hardship for poor people was a subtle shift away from the court's prior decision, which found that because women are poor of their own making, having nothing to do with the state, they shouldn't expect that state governments would help them pay for their abortion, even if the state helped them pay for pregnancy-related services. Following Whole Women's Health in June, reproductive rights activists rejoiced. Finally, the court cared about impact. They cared about real people's lives, poor people's lives. In my work, which I won't discuss in detail here, this raised important questions about who the experts were that speak for and about the impact of regulations, the role of the courts in legitimizing these various claims, and the relationship between competing activist and scientific positions in staking a claim. While those questions are still relevant, unfortunately with Dobbs, the possibilities of the undue burden standard were short-lived, and we returned to the 18th century logics of what matters, who matters, and why. So I'll just end my comments by putting Professor Fleming's book back on the table and offer his call to you all again, which he had put up on that slide at the end there, with a plea for progressives to be more critically engaged with lawmaking. This is what I read into Professor Fleming's book. Maybe I was projecting. But especially to be critical with the decisions of the Supreme Court with which they disagree, and think critically too about the institutions and the institutional formations that make them possible. Thank you, Professor Fleming, for writing this book for all of us, and so really setting the stage forward for another way that is possible, and a constitutional doctrine that has an eye really towards building a better society that respects diversity and pluralism. Thank you.
Professor Gary Lawson. My designated role on this panel is to be the critical commentator, and Jim has made that very tough. How do you argue with Dylan? So without in any way suggesting that this is a comparable authority, I'm going to counter with the boss. Instead of waiting for a hard...
Please don't quote Bruce against me.
I got two of them. Instead of waiting for a hard rain to fall, I think Jim should be drinking warm beer in the soft summer rain. Now, let's be very clear. For someone with Jim's value system, it is the rain song. Goodbye, blue sky, right? It's not happy times. But I don't think the rain is quite as heavy as he thinks it is. To come in with the boss once more, I don't want Jim to think he's getting lost in the flood. What do I mean by this? Well, I'm going to offer what I think is a provocative thesis. If Jim sat down today to do a new edition of his book, I don't think very much would have to change. He could choose to make very substantial changes in it, but I don't think he would have to. This book is part of a, I will say, lifelong project that Jim has been engaging in. So it has to be seen in the context of a whole bunch. It stands on its own, but it's also in the context of a whole series of other books, which unfortunately we have both been reading for longer than either of us would care to think about. But for that larger project that Jim's been engaging in for quite some time, the actual case law plays an important role. It's not a decisive role. It's not a purely descriptive account. It's partly normative. But the cases do form the data set around which everything operates. And here's the thing. The abortion cases have always been outliers in that data set for a very simple reason. Jim has an entire chapter in his book where he argues, I think quite convincingly, that the cases he describes have never been imposing a John Stuart Mill on liberty harm principle, so that no legislation nothing can be prohibited by legislation unless it causes some kind of concrete harm. He's right, that's never been the law. But it is the case that in most of the cases that form his data set, there are always third-party effects. There's no such thing as something without third-party effects. You're sitting in your living room doing whatever it is you want to do. There could be someone out there who's unhappy at the prospect that you're allowed to sit in your living room doing something. So there's always third-party effects. It's just that in some instances, they're pretty attenuated. And in most of the cases in Jim's data set, they are attenuated. The abortion cases, as the Supreme Court's majority opinion in Dobbs said on 5 occasions that I counted, and I probably missed a few, it's different. The third-party effects are much more apparent. 60 million dead babies is a lot of third-party effects. Aha, you say, though. They aren't really dead babies. And that is the question. That is precisely the question at all. Moving your arm, absolutely the sort of thing you would think of as an aspect of fundamental liberty and bodily integrity. Unless it happens to be holding a knife that gets jabbed into Salman Rushdie's neck. Then, not so much. Is abortion like moving your arm, or is it like moving your arm while holding a knife that goes into someone's neck? That is precisely the question that the Dobbs case says the Constitution of the United States does not answer. It's a very specific question that it does not answer. And by the way, that holding is a huge defeat for a good chunk of the pro-life community, which has long maintained that states are obligated to prohibit abortions as a matter of equal protection. Dobbs does not support that view and indeed implicitly defeats it, and Justice Kavanaugh's concurrence totally defeats it. All right. Bottom line is, if you pull the abortion cases out of the data set, Jim's book still stands, right? Those are not an essential component of the large line of cases. You can take them out and very little changes. But Jim's focus is not just on the outcome, it's also on the methodology. And he worries that the methodology foreshadows additional pullings out of the data set. I mean, if you take, 9 out of the 10 cases out of the data set, yes, then you're dealing with a very simple thing. So doesn't the methodology that the majority applied in Dobbs indicate that a good chunk of the cases in that data set are, number one, wrong, and number two, should be overruled? Well, thing to note is those are two distinct questions. To say that a case is wrong and to say that a case is overruled requires two distinct analytical moves that are not necessarily connected. And this is where I think Jim is running too quickly to his umbrella, Ella. Everyone here would agree that the current Supreme Court is a conservative court. What I think people will not necessarily agree on is what that means. What does those terms describe? First of all, to say that it's a court is something of a mistake. It's a collection of 9 people, not an organic entity. That's number one. Number two, what would it say to say that any one of those 9 people is a conservative jurist, a conservative justice? Turns out that's a very, very ambiguous term. Now, Jim in his book actually tries to distinguish what he calls preservationists, the poster child there being the second Justice Harlan, from counter-revolutionaries, the poster child there probably being Clarence Thomas, although Justice Scalia would also stand in there. And I think he's getting at something, but I think it's much more complicated than that. Figuring out what it means to talk about a conservative court is not a two-body problem. It is a multi-body problem. And just like in physics, multi-body problems are, if not insoluble, then at least very, very difficult to solve. I would identify at least 3 genuses of conservative justices with a plethora of species within each genus. For lack of better terms, I'll talk about conservative constitutionalists, conservative traditionalists, and conservative institutionalists. And they are very, very different creatures. No person in reality corresponds perfectly to any of these. They're ideal types. I like to think of them as gravitational bodies that exert gravitational force, and the force will be strong in this one and not quite as strong in that one. So these archetypes are pulling, tugging on different people in different ways. Sometimes there's a Jupiter effect, right? And they all line up and they're all tugging in the same direction. That's what happened in Dobbs. But there's a whole range of cases where these things are tugging in very, very different directions depending upon the constitutionalist. Define briefly what I mean by that. A conservative constitutionalist would be someone who thinks cases should be decided in accordance with the communicative meaning of the Constitution. A conservative traditionalist would be someone who thinks cases should be decided in order to maintain a particular kind of social structure. And a conservative institutionalist is someone who is worried about things having to do with the court as an institution, its public perception, its political capital, its continuity over time, which is where the concept of precedent enters in. And as I say, these things affect different justices in different fashions, but here's the overall observation, and I say this as an originalist. This is not an originalist court. This is not a conservative constitutionalist court. There are a couple of justices for whom the force is strong in that one, but only a couple. There are a whole lot of pulls, tugs going on. And those pulls and tugs, particularly from the institutionalist side, not only have implications for the first, our case is wrongly decided, but also very importantly for the second, should cases be overruled. And I say this as somebody who's written a law review article called The Constitutional Case Against Precedent. But I'm not on the court, and I never will be, right? They're not me, they aren't, okay. What if they were? What if we had 9 Justice Thomases saying the things out loud that Jim said? What would that mean for his data set? Well, here's the last thing I'm going to say. I think 2 of the most important paragraphs in Jim's book are on page 19 and 20. I'm just gonna read them. Yeah, people who've had constitutional law already will recognize this. People who haven't, I don't think will appreciate how momentous this is. In the slaughterhouse cases, 1873, the first judicial interpretation of the 14th Amendment, given 5 years after its ratification, the Supreme Court gutted the Privileges or Immunities Clause. That is an understatement, by the way. Although the dissenters interpreted the 14th Amendment as a whole as a new Magna Carta, and the Privileges or Immunities Clause in particular as protecting natural and inalienable rights, those which of right belong to the citizens of all free governments, a proposition, by the way, that every contemporary originalist of which I'm familiar thinks is obviously correct. The majority limited the clause to protecting only those rights which owe their existence to the federal government, its national character, its constitution, or its laws. Well, okay, when the 14th Amendment was ratified, everybody understood the central provision, the thing that was actually going to do most of the work, was the Privileges or Immunities Clause. 5 years later, the Supreme Court wipes it off the constitutional map. And Jim's next paragraph, I'm not going to read the whole paragraph, describes accurately how the history of the last century and a half has been the systematic use of other provisions of the 14th Amendment, the Due Process of Law Clause and the Equal Protection Clause, essentially to undo some of the damage done by the slaughterhouse cases in 1873. Bottom line is that if you had 9 conservative constitutionalists, yes, they would conclude, as Justice Thomas would conclude, as I would conclude, that the Due Process of Law Clause just doesn't do that kind of work. It wasn't meant to. Justice Thomas also wants to restore the original meaning of the Privileges or Immunities Clause. He would overrule not only Jim's cases, but the slaughterhouse cases as well. And that is why he says, quoting his opinion here, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. After overruling these demonstrably erroneous decisions, here we go, the question would remain whether other constitutional provisions guarantee the myriad rights that our substantive due process cases have generated. For example, we could consider whether any of the rights announced in this court's substantive due process cases are privileges or immunities of citizens of the United States protected by the 14th Amendment. Right? So if you're really trying to figure out what the world would look like if you had 9 conservative constitutionalists, which you don't, you have like 1 1/3. But if you want to know, you would have to think not only, okay, we've gotten rid of substantive due process, but what would the Privileges or Immunities Clause do? Without getting into it here, does it do everything Jim wants? No. Does it do a lot of it? Yeah, it probably does, a whole lot more than one might think. But what complicates the predictions of what is going to happen is that's not what's driving the boat. What's driving the boat for a lot of the other people are these considerations of what I call traditionalism and institutionalism. And I don't have, I'm neither of those things, so I can't get into their heads. But that's a much more complicated inquiry as to what the future is going to look like than if we simply take the substantive due process doctrine in the abstract and go from there. All right, the one thing that I think we will all agree on is something Jim said during his talk, and that is very unlikely that you're going to get a lot more Obergefells and Caseys and Lawrences and those sorts of things. You can't always get what you want. And on that, let's go to see if there's a colloquy among the panel, and if not, we will go to questions from all of you. I don't know, do we have a way of getting questions from room 209? I don't know that we have, no, we do not. Okay, sorry about that.
Okay, first of all, thank you both for those careful and thoughtful remarks. And Aziza, welcome to the faculty, and I appreciate your remarks. And I appreciate your words of support and also the complementary work that you do to what I try to do as we try to work toward doing what we can to achieve what constitutional justice and political justice we can in the next generation and beyond. So I'm gratified that you've reaffirmed the importance of some of these strategies that I had closed with. I also think that your work and the arguments of the reproductive scholars, I think, has a great deal of affinity to the kind of work that I try to do in this book. Now, I have a few comments on what Gary said, but I do want to get to questions. So first of all, I've never been a Chicken Little kind of a guy, and so I hope I didn't sound like it in these remarks. And I think I've always tried to see, I've always been accused of thinking the grass was greener on my side of the fence. Okay, so I'm the opposite of that. And I always try to exercise interpretive charity. But those strategies are, frankly, are failing me as I read Dobbs and as I contemplate the aggrieved, as I contemplate the court we have now, especially as presented through the really terrific work of Linda Greenhouse and others, that there are, especially Alito, but others, angry grievance conservatives. And boy, if there has never been such a full statement of angry grievance conservatism as Alito's opinion in Dobbs. And I do know that a lot of people, including people who are trying to make the best they can of a bad situation, say, well, look, let's see if we can just put abortion off to the side. Well, first of all, let's not lose sight of the fact that that's an awfully significant thing affecting millions of lives that I really don't think we should say, let's just put that off to the side. And but I also think that what agitates me about Dobbs beyond its outcome and its reasoning is that there's every reason to believe that at least 4 of the justices and probably 5 are ready to overrule a lot of the precedents, that they not just think they're wrongly decided, but they do want to overrule them. And a lot has been written in the last couple of years about what a hearty appetite this court has for overruling precedents. So I just don't really see any institutionalists there except sometimes Chief Justice Roberts, and on very rare occasions, Justice Kavanaugh. Sometimes he tries to join with Roberts and masquerade like an institutionalist. But I don't see anybody other than Roberts who comes close to being anything like the conservative institutionalists you distinguished, or who I think are very much the same as what I called the preservative conservatives. Okay, and I think your conservative constitutionalists and conservative traditionalists are both, they're just particular specifications of varieties of counter-revolutionary conservative, because they really do want a counter-revolution against the liberalism that they think has destroyed our country and perverted our Constitution, to track both, to link up with each one of them. So I think that especially because of the dissents they've written. For example, even Roberts' dissent in Obergefell reads, for the first dissent I ever read by him, that read like a Scalia dissent. The rage in that dissent, the outrage in that dissent. And finally, I want to say that you say this is not an originalist court. Now, I do think when Kavanaugh was nominated, I remember a very good op-ed in the New York Times by Eric Posner and Emily Bazelon, saying Kavanaugh is not an originalist. And I think that Kavanaugh did not present as an originalist in 2018. And obviously, Alito never presented as an originalist. But when he needs to be one in the culture war battles that he's most deeply committed to, he dons the garb of an originalist. And so it's little consolation that, well, he's not a pure originalist the way Thomas is, because I think they're likely to join on a lot of cases that are going to be very important. And also, I do think that I want to add a footnote and take partial exception to what you said when you implied that Dobbs was somehow like a defeat for some parts of the pro-life
They think so.
movement. Right. Now, I don't, well, first of all, I don't see it that way, and I'll just zero in on what I mean by that. I think that the briefs Alito cites in substantive due process cases and in Windsor, his favorites are the Robbie George briefs, okay? And so you know where I'm going with this, okay? Oh, yeah. So the Robbie George brief does argue that these materials, these historical materials that say there was no right of a pregnant woman to decide to terminate a pregnancy in 1868, you know what else they say? That a fetus was a person, right, and had to be criminalized and had to be prohibited under the Constitution. That's right. Okay. And so I think if Alito goes whole hog with the people he usually agrees with, Robbie George, Sheriff Gerges, and Ryan Anderson, that's where he's going. The fact that he couldn't get there this one day on this one case where there was no occasion to go all the way there is no consolation. And I think it telling and significant that Kavanaugh felt it necessary twice in that concurrence to stress we are not holding that the Constitution prohibits abortion. And I believe he thought it necessary to say that not once but twice because he counted 4 who thought that's what the Constitution does believe. I think he counted Clarence Thomas, Amy Coney Barrett, Alito himself, and Gorsuch. I think he counted 4 who believes that what the Constitution says. Let's remember that in Gorsuch's book on physician-assisted suicide, the phrase that worried the liberals the most was that he implied that states could not permit aid in dying, that the Constitution required them to prohibit aid in dying. Well, take a small step from that to the Constitution prohibits abortion. So let me just stop there because I want to allow questions. But there was a lot you put on the table there that I wanted to touch upon. And in responding to you, I've touched on some of the concerns about some of the folks in the audience. Yeah.
We have a microphone for you.
All right. I guess I'll be the one calling on people. I know there was a hand right in front if you were looking for the microphone. Then there was someone farther back. I'll pick you up next. And by the way, should identify yourself.
Oh, hi. Thank you. My name is Jenny Kramer. I'm a BU SL alum of a long time ago. And welcome. I just wanted to say that if you were looking at just this decision alone, I could give a modicum of credence to the things that you said. But this court is off the rails, unrestrained, and is only getting started. the decisions that came out at the end of June, when, we the people were finishing up the school year, dealing with the end of the pandemic, working and doing all the other things, is not even on the radar of most of the American public. The gutting of, administrative law, essentially, of Chevron, the ability of expert agencies to deal with the gun law in New York. I know I'm forgetting many things, but that last week in June that, told us that now is the time to break the glass. We're living in an emergency. This court is only getting started, and women are dying every day in this country because some doctor somewhere doesn't think they're close enough to death's door to perform a procedure. These are mothers, these are sisters, these are daughters. This is just an all-out emergency. And I think that we need, as a country, to let this court know that it is off the rails and that we do not agree with it. And I think a great way to do that, and I'm surprised and saddened that people with a platform haven't said this, is to show up on the steps of the Supreme Court on the first Monday in October and let them know. We are watching them, we are reading these opinions, and we are not going back.
Nobody that I hang around with would say anything other than, yeah, absolutely, if that's your view, go for it. Yeah, there was definitely a hand back there.
Hi, my name is Sydney Cesaro. I'm a 3L here. I guess going off of that, I had a question. So I think obviously a lot of Americans are concerned about the legitimacy of the court, and Dobbs was just kind of brought that to a head in light of a bunch of other decisions, and a lot of Americans have lost faith in the court. So I was just wondering if you all could speak a little bit to where the Supreme Court goes from here as an institution and gaining kind of American trust and faith back in it once again.
I'm going to duck that one. I am not a social scientist. I'm barely a lawyer. So I think I can, read opinions and read statutes and do that, but trying to project social trends, we have people on this faculty with PhDs in sociology, and I would defer to them.
Anything you see?
Oh, sure. Oh, I would just say that I think a lot of it is going to depend on sort of the mobilization that occurs outside of the court. Like the last speaker, I'm so sorry, I don't know your name. Ginny. Like Ginny said, that the Supreme Court, whether or not we want to believe it, like other legal scholars have said, they're not magical beings that put on robes and enter into a courtroom and somehow exist floating above society. They're in society with all of us. And the decisions impact what we think of as sort of norms and values, and our norms and values shape how decisions are going to be read and understood. And I think a lot of this is going to come down to the public discourse outside of the court, and mobilization that happens outside of the court, and showing up at the court and making sure that the Supreme Court knows that they are being listened to and watched and read carefully. This idea that, and I feel like it's been attributed to Justice Roberts recently, that somehow the decisions shouldn't matter for the legitimacy of the court is kind of absurd, So I would support the first question, Ginny's thoughts here, and how we can actually maybe bring change even in the current configuration of the court.
I think the difficulty in making any headway on legitimacy is that many conservatives, to the contrary, celebrate Dobbs as a restoration of constitutional legitimacy after 50 years of illegitimacy, which we had seen as, in other words, the legitimacy conflicts are going to mirror the polarization in the country. Now, I think Dobbs is a restoration only in the sense that a counter-revolution restores an old oppressive order. it doesn't gain legitimacy at all. But I also am concerned because were there more institutionalists on the court, I would have more confidence that they might be moved by this. And let's be clear, the way a social movement works is not like putting pressure on people and in some crude way they have to follow the election returns. Rather, it enables people to understand the world in a way that enables them to see the analogies they have not seen before. For example, the LGBTQ rights movement from Stonewall to Obergefell. It's not that judges looked out and said, uh-oh, there's a movement, we gotta heed what they're saying. It's rather that they communicated the basic humanity of LGBTQ folks. So we went from Justice Powell in 1986 saying, quote, I've never known a homosexual, as he put it. He said that to one of his clerks who was gay. We go from there to a world where Justice Kennedy emphasizes that this is just the right that straights have. We're just extending the right that straights have to folks who want to engage in same-sex intimacy. So it's through making them understand the world, making them to see these analogies differently. It's not just pressure, as it were. But because I don't think we have any more than 1 or 1 1/4 institutionalists on the court, I still await more creative thinking on this point than I'm capable of.
All right, I'm going to go to the right side now. There's a gentleman there, and then I'm going to pick you up. And then I'm going back over there.
Hi, I'm Andrew. I'm a 1L. My question is mainly for Professor Lawson. As an originalist, as an originalist, do you think there would ever be a time where you could concede that the court would have to take into consideration like its popularity or like how much a decision would be unpopular with Americans? My main thinking is like if the court were to overturn like Obergefell, like don't you think that they would have to at least take into consideration with that opinion how the entire country would react to that?
All right, this is going to sound like a BS answer, but people who know me know that it's not. When I say I'm an originalist, all I mean by that is I think that the communicative meaning of the Constitution is determined by looking at the conceptual framework from the time that it was ratified. I don't actually prescribe any particular mode of decision. Deciding how a case should come out, I don't actually think is a legal question. I think I agree with Jim on this. I think it's a question of moral and political philosophy. And I'm not a moral and political philosopher. So in my academic guise, I actually don't prescribe how I think cases should come out. I just make descriptive claims about how I think decisions are best read in their communicative meaning, how statutes and constitutional provisions are read. So I genuinely don't have a position on that. And again, people who know me well enough know that I really genuinely don't. So it's to me an unanswerable question. I don't have a set of criteria for what I think makes a decision correct. If I thought that decisions should be made based on the communicative meaning of the Constitution, I would answer that question no, because I don't think that's something that enters into the communicative meaning. But the actual decision process, this is why I say nobody in the actual court now or in the past or in the future purely conforms to any of these archetypes. There's a tug of forces and pulls more in this way and it pulls less in this way, and Thomas is pulled this way and this, and Roberts is pulled a little more by that, right? But those are all pulls and tugs. And I've never gone into print with a grand theory of adjudication because I view that as a species of moral and political theory. And Jim's got a PhD in political theory. I got a freaking BA in philosophy and a JD, all right? It's not what I do. So I appreciate that it's a great question, and I'm the wrong person to ask it to.
Hi, I'm Hannah. I am a 2L, and I was fortunate to have a Professor Lawson last year and Professor Fleming. I'll be taking your class next semester, and I'm taking Professor McLean's class this semester. So got the whole package. So my question, I guess, is on the 9th Amendment. So we touched upon it very briefly in constitutional law and here and there. And I'm just curious why it seems that substantive due process and basic liberties and the conversations around that have really been funneled through, 2 words of the 14th Amendment, when it seems like the 9th Amendment, which just as a layperson would suggest that there are these basic liberties, and why the court hasn't featured so prominently.
Is Michael Westbrook funneling questions through you? I see Michael back in the back there. He's a 9th Amendment buff. I think I love the 9th Amendment. I've written about it. I teach about it. I interpret the 9th Amendment as a rule of construction of the Constitution as a whole. That is, it tells us on the face of the Constitution, in part, how to interpret the Constitution. The 9th Amendment says, I know it by heart, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So I read that to mean, on the face of the document, do not read the Constitution the way Justice Scalia and Justice Thomas and Dobbs said it ought to be read, okay? Do not read it to say that just because a right is not enumerated, it is not protected. But it's not a substantive source of rights, on my understanding. And so I think Justice Goldberg's concurrence in Griswold had it exactly right. When he said the 9th Amendment is not a source of substantive rights, but it justifies what we've been doing.